Meghna Sridhar, and I'm a senior associate at McAllister Olivarius. As lawyers representing survivors of sexual abuse, one of the biggest challenges we see in bringing cases forward is what's called a statute of limitations. Many survivors assume that if they've been assaulted, they can bring a claim against the individual or the organization at any period of time. Unfortunately, this is not always the case. This is an area of law that can be quite frustrating and upsetting to survivors, and so it's important to spell out exactly what a statute of limitations is and how it can affect a potential case. A statute of limitations is the time period after a legal wrong has occurred within which someone can bring a claim. These vary wildly. They differ based on the jurisdiction that you're in, they can differ based on where the harm occurred, they can differ based on which laws apply or which legal theory you're bringing your case under. For example, the time period you have to bring a claim can be different based on whether it's a medical malpractice lawsuit or an employment discrimination lawsuit or a Title IX educational case or a personal injury case. These periods can vary from anything to less than a year, which is usually the case in employment discrimination, to 20 years or 30 years is the case for some jurisdictions in child abuse cases. Perhaps one of the biggest challenges with statutes of limitations is that they rarely match the reality of trauma. One study with over 1,000 participants found that the average age that a child abuse survivor comes forward is 52 years old. As lawyers representing survivors of sexual abuse, we often find that it takes a long time for people to come to terms with what has happened to them, and it takes even more time for people to come forward and consider bringing legal action. When limitations periods are unjustly short, this stops a lot of credible survivors of sexual abuse from getting justice and accountability for what's been done to them. Fortunately, many jurisdictions are recognizing that unfairly short limitations periods are an unjust bar to most survivors. A lot of jurisdictions are now reforming their laws and increasing the time period within which abuse victims can come forward with claims. Unfortunately, most of these changes are prospective in nature, meaning that they only apply to assaults that occurred after the law has been passed. However, many states are also opening look-back windows, which are time periods within which survivors can bring any claims, even if they are otherwise time-barred. New York and California, for example, in recent years have opened windows for survivors of child sexual abuse to come forward, no matter how far back the abuse occurred. These windows have been enormously successful in empowering survivors of historic abuse and allowing them to hold the organizations that facilitated that abuse to account. All of this is to say that while statutes of limitations can be a significant hurdle in bringing forward a civil sexual assault case, the determination is always one that is highly fact-specific, and if you are considering bringing forward a case, you should always speak to an attorney. This area of law is complex, it is ever-evolving, and it is a highly fact-specific determination. And even if your claim may be facially time-barred, it's always worth exploring your options with an experienced attorney.